In this video, I'm going to share with you 5 common objections that is typically raised in family court. Now, be sure you watch the whole video so that you'll get all 5 objections so that you will feel that much more confident when it's your time to represent yourself in family court. If you're new to this channel, welcome. My name is Nashia and I am a family law attorney, and I'm very, very passionate about helping people in the area of family law. I understand that there are times where people can't afford a family law attorney, and so I like to make content that helps to arm people with information so that they will feel that much more confident when they have to represent themselves as a pro se, what we call a pro se litigant. Now, as you can see from the title of this video, I'm going to be giving you 5 common objections that you can make, that people typically make in family court cases. Now, a brief disclaimer, just a brief disclaimer. I do have my outline here just to make sure that I stay on track. So if you see me looking off to the side, that is why. Okay. All right, let's get straight to the video. Number 1, leading questions. Now, please like this video and let me know if you've ever seen a legal movie, TV show where you've seen a person say, "Objection, Your Honor, this person is leading the witness." Leading questions is a no-no. You cannot ask leading questions during direct examination. You can during cross-examination, but I don't want to confuse you. So for now, just know that if you are calling your witness, it is your witness on direct examination, you cannot ask a leading question. What is an example of a leading question? An example of a leading question would be, isn't it true? Isn't it true that you said you would pick the child up at 7 o'clock and you didn't come until 8 o'clock? That's a leading question. So to stay away from that, you want to ask open-ended questions. Who, what, when, where, why? Open-ended questions during direct examination, okay? Now, again, on cross-examination, you can lead the witness. So say, for example, if the other party is testifying during their case in chief, and the judge says, well, would you like to cross-examine the witness? When it's your turn, you can then ask leading questions. Now, let's move on to number 2. Number 2, hearsay. Now, hearsay, this is a very, very common objection in family court cases. And it may be for a reason that you probably already know, or maybe not. I don't know. Let's see. So, hearsay. Hearsay is defined as any statement made out of court that is now being offered in court to prove the truth of the matter asserted. Now, that is the legal textbook definition. But for the purposes of this video, I'm going to state it in plain English. Basically, hearsay is any statement that is made outside of court that you're now trying to bring in court. Now, there are exceptions to the hearsay rule, but I won't go through them in this video. If you are interested in learning more about those, please let me know by hitting the like button or leave me a comment down below, and I will be happy to make a video explaining some of the hearsay exceptions. But for the purposes of this video, just know that you cannot bring statements that were made out of court in court. Now, this comes up a lot of the time when it comes to a parent trying to tell the court what the child said. Well, Your Honor, my son told me, Your Honor, my daughter said that her father did X, Y, and Z. Objection, Your Honor, that is hearsay. I object all the time. All the time. When I'm in court and the other counsel's witness is testifying and trying to bring in hearsay, objection, hearsay, hearsay. Cannot do that, okay? So just keep that in mind. You cannot say what somebody told you, what somebody said. If they're not in court to testify for themselves, you cannot offer that statement in court. But there are some exceptions. And again, I'll talk about that in another video. Number 3, ask and answer. Objection, Your Honor. Ask and answer. Now, this may be one that you may have not even heard of before, but I'm just like a nerd when it comes to like objections, because I love learning about them and I love just using them in court and just to practice being a better trial attorney, a better litigator. And so I typically will review the objections just to make sure that I'm keeping them fresh in my mind. And I actually used this objection a few days ago, well, last week, by the time you watch this video, during my first jury trial that I had. And the judge sustained my objection. And I'll talk a little bit more later in the video about the difference between sustain versus overrule. But for asked and answered objection, it means that you can't ask the same question over and over again. And a lot of times people will do that because they try to get a different response because they didn't like the response that they got. So let me give you an example of that. Let's say you are questioning the other parent on the stand and you ask the other parent, did you tell me that you were going to sign up for our family wizard? And let's say the parent says, I don't know. And then your next question is, well, think about it. Did you tell me that you would sign up for my family wizard? Objection, Your Honor. Asked and answered. This question has already been asked and answered. Now, a lot of times people may try to get slick. They won't do it in the way that I just did it, asking the question back to back. They may ask the question and then ask some other questions and then go back to that question just to see if they can catch the person up in a lie, to see if they'll change the story. But if that happens, just know that a person can object to that, because you cannot ask the same question multiple times just because you don't like the answer that you got, okay? So that's number 3. Number 4, speculation. Speculation. Now, an example of this would be, let's say, for example, if you're trying to ask a witness, well, what do you believe? When you hear words like believe, or what do you think the other person said, or what do you believe the other person may have done? You cannot speculate, which means you cannot guess or assume what another person would have said or would have done. That would be an objection based on speculation. Now, last but not least, for the purposes of this video, lack of foundation / lack of authentication. But basically what this means, and this applies to family cases a lot of times, because a lot of the evidence that is sought to be introduced in family court cases are text messages. Oh my gosh, it's text message heavy. Text messages and photos. Now, you cannot just show up with a stack of text messages and say, Judge, please look at these messages. Or you can't just go up to the witness and say, in this message, does it say that you said you promised that you would return back the child's clothes? No, you have to establish a foundation before you start to question the witness about the text message. So what are some things that you may do to establish a foundation? You may say, do you recall sending me a message on June 2nd, 2022? And the witness may say yes. And in that text message, do you recall telling me that you promised that you would return Johnny's clothing? Well, yes, I did. Then you would ask permission. You would stand up, ask permission to approach the witness. You'll go to the witness. And there it may be, again, this is just generally speaking, is very jurisdiction specific. But I'm just going through this just to kind of give you an idea of what this may look like. So again, you have to set the foundation. You ask the person, do you recall sending me a text message on June 2nd? Do you recall texting me that day? Yes. Do you recall sending me a message telling me that you would promise to return little Johnny's clothes? Yes. Your Honor, this time, let the record reflect that I'm referring to has been marked as Plaintiff's Exhibit 1 for identification purposes only. Your Honor, may I approach the witness? Go approach the witness. You show the witness the document. You say, I'm showing what has been marked as Plaintiff's Exhibit 1 for identification purposes only. So-and-so, what is this? And that person should be able to say, this is a copy of the text message that I sent to you on June 2nd, 2023. Then you would say, well, is this a fair and accurate depiction or a fair and accurate copy of the text message that you sent to me? The person should say yes. Has this been altered or changed in any way? The person should say no. Do you see the phone number that's at the top of this text message? Yes, the number is 222-222-2222. And is this number your cell phone number? Yes. And have you had this cell phone number for a certain period of time? Yes. So those would be the steps that you would take to establish a foundation and also to properly authenticate the text message before you can then ask the court to accept the text message. And so after the witness properly authenticates the text message, then you can ask the court, Your Honor, at this time, plaintiff offers into evidence Plaintiff's Exhibit number 1, something along those lines, okay? So that will be an example of a proper foundation and proper authentication. Now, if a person does not take those steps, to make those necessary steps to do that, then you could object and say, Your Honor, there's been no foundation. Your Honor, lack of authentication, okay? So that would be number 5. So as a bonus, okay, as a bonus, I promise you that I will tell you the difference between what sustain means and overrule. So if a judge sustains an objection, that means that that witness cannot answer that question, okay? And if it's a document, that means that at that point you cannot introduce that document. Now, if the judge overrules the objection, that means that the person on the witness stand can continue with whatever they were saying, which means that the judge said, well, I heard your objection. I don't agree. The witness can continue. Okay? So those are 5 common objections in family court. If you found this video helpful, please let me know by hitting the like button. Also, if you'd like to see a part 2 where I can talk more about other common objections in family court, please let me know in the comment section down below. And until next time, thank you so much for watching. Be blessed, stay blessed, same thing. I just like to say it twice, and I'll see you all soon. Take care. Bye-bye.